Hello friends. Welcome to Current Affairs Review. Topic for today's video is Anti-Defection Law, a legal fiction? India saw worrisome levels of political corruption in the 1960s and 1970s, which called for the establishment of a regulatory framework to control defections. The fall of Morarji Desai's government in 1979, engineered by the defection of 76 parliamentarians, triggered massive public disapproval. Sensing the need, in 1984, the Rajiv Gandhi government had legislated Anti-Defection Act 1985 and added it to the 10th schedule of the Constitution through 52nd Amendment in the same year. So what does the Anti-Defection Law states? First point states, if an elected member voluntarily gives up her membership of a political party that she belonged to while contesting in elections. Secondly, if she votes or abstains from voting in the House, contrary to any direction issued by his political party. Thirdly, if any independent member joins any political party after the elections. And lastly, if any nominated member joins any political party after the end of 6 months from the date of elections. Although there are few exemptions, like if 2/3 of the legislators of a political party wholesomely decide to merge into another party, any person elected as chairman or speaker can resign from his or her party and allow parties to be split, only to be outlawed. Further, the Act explicitly states that any question regarding disqualification arising out of defection is to be decided by the presiding officer of the House. The court remarked that while adjudicating cases under this law, presiding officer functions as a tribunal and hence is subject to the judicial review. It is a mockery of representative democracy that most voters choose politicians based on their enthusiasm for and commitment to the political party to which they belong, but if those candidates defect, they cease to represent the interests of the people. The political stability is seriously threatened by defection because there have been more than 5 instances of democratically elected administrations being overthrown by defectors in the last 3 years alone. Representatives, rather than siding with public's will, would indulge in offering themselves for sale. As a result, legislators are increasingly becoming a commodity which can be bought at will. When the threat of defections constantly hangs down the neck of governments cannot function freely. The Act was brought with the right intention to prevent representational democracy from descending into a mere number game. Some of the intended merits of the Act were: provide stability to the democratically elected governments, provides assurance to the governments to not be constantly worried about keeping the flock intact, provides intra-party discipline, ensures the preservation of public's will till the next elections, ensures that legislators adhere to the party's manifesto. A conflict of interest arises where presiding officers have been invested with the powers to adjudicate defection cases, in which their mother party is a key litigant in most of the cases. The Act doesn't specify any set time frame within which the presiding officers have to adjudicate the defection case. When a member or group of members belonging to majority party resign en masse, the strength of the legislatures come down and the ruling party may lose the majority mark. In 2016, SC ruled that the Speaker cannot go ahead with disqualifications if there is an active removal motion pending against her. Hence, the defectors may use this judgment as a legal loophole to evade the wrath of the Act by merely filing a notice seeking her removal. Download material for this issue from our website. Please like and share this video. Please subscribe our channel and hit the bell icon to stay updated. Thank you.